Hi everyone, my name is Haroop Boldukian. I'm a practicing bankruptcy attorney here in the state of California. Now, if you've come across this video, it's probably because you have some sort of debt that you're dealing with, whether it's credit cards, whether it's medical bills, student loans. So what are some of the options of what you can do when you're in debt? One of the main options is filing for bankruptcy protection. When you file for bankruptcy protection, you have to qualify for certain chapters. It all depends on things like your income, things like your assets, and the type of debt that you have. Some debt may require you to file a Chapter 7 or a Chapter 13. Your income may help you qualify for a Chapter 7. If your income is a little high, you may end up having to file what's called the Chapter 13 bankruptcy. Or if you have assets, anything that you own that can't be protected in your Chapter 7, you'll end up likely having to file a Chapter 13. Your assets and your income play a major role in determining what chapter you qualify for. A lot of times when people call my office, they want to file for bankruptcy. They don't necessarily understand that there are different chapters available to them. And so they're calling because they want to file for a Chapter 7 bankruptcy. When you're filing for a Chapter 7 bankruptcy, that is the liquidation bankruptcy, so it's called. It's technically the straight bankruptcy. It's the bankruptcy you hear about all the time where you're getting a discharge or erasing of your unsecured debt. When you call a bankruptcy attorney, your main goal is, hey, I can't pay this debt off. I need to file for bankruptcy because the payments are too high. I just can't do it anymore. My income's not going up, and I'm just kind of drowning in debt. So some of the questions that they're going to ask you during your initial consultation are things like your marital status. Are you married? Are you single? Are you looking to file individually? Are you looking to file with your spouse? That all comes into play. Here in the state of California, California is a community property state. So a lot of times people will call my office, they're married, and they want to file themselves. They don't want their spouse to get involved. And I always tell them, we're in California, this is a community property state, so although you may want to file and your husband doesn't want to file, or if your wife doesn't want to file, we still have to disclose their assets, their income, your household assets and income essentially for you to qualify for that Chapter 7. A lot of times people will have one spouse file and another one not file to preserve the other spouse's credit, but you're still preparing the paperwork as if that individual is a part of the household. Now, the spouse's credit is still protected, but you are going to have to provide that information from your spouse in order for you to qualify for your Chapter 7 bankruptcy. Some of the other questions that they'll ask you is, have you filed for bankruptcy before? When you file for bankruptcy protection, you can only really file a Chapter 7 once every 8 years. So if you filed within the last 8 years, a Chapter 7 is not going to be an option for you. You're likely going to have to file either a Chapter 13 or work on an alternative as far as alternative debt relief solutions like a debt settlement or debt consolidation, or just another route other than filing a Chapter 7. They're also going to ask you things about your assets. When you call a bankruptcy attorney, one of the main things to help you qualify for a Chapter 7 is to determine if you have assets that are too valuable for a Chapter 7. Here in the state of California, we have a set of exemptions to protect your property. There are two sets of exemptions here in the state of California. Easiest way to break it down is one set of exemptions is for people who have a home. The other set of exemptions are for people who don't have a home. And they each have different dollar amounts and categories in there for protecting assets. But your attorney is likely going to ask you during your initial consultation, what assets do you have? Do you own any real estate? What's the value of the real estate? How much do you owe against it? Are you leasing or financing any vehicles? Or do you own your vehicles? Do you have any recreational vehicles like a quad or a dirt bike, a boat? These type of assets need to be disclosed in your paperwork, and the appropriate exemptions need to be used to protect them so there's no risk of losing them in your case. A lot of the times assets will also include things like retirement accounts, whether it's a 401k or a pension plan. Retirement, 401k, IRA, pensions, those are usually fully protected in your bankruptcy, so you're not going to be required to pull money out or anything in order to pay off your creditors or lose a portion of that. Another asset that some people don't think about are stocks, bonds, mutual funds. If you were somebody that got into the cryptocurrency game and you have valuable cryptocurrency, a lot of trustees are asking questions about the value of the cryptocurrency regardless of where that market is right now or what's going on with Bitcoin or Ethereum or the blockchain or what have you. Trustees are going to ask, is there a dollar amount that you have a right to? Is there a Coinbase wallet somewhere that has money in it? And these are all assets that need to be disclosed. Another asset that some people might not think about, a trustee will look into, your attorney is going to ask, are you suing anybody? Do you have any claims against anybody? Were you in a recent car accident? Do you have a workers' comp claim? Does anybody owe you money? Did anyone take any money from you? A right to sue a third party or a claim against a third party is actually an asset in your case and can be pretty valuable. So you want to make sure you disclose all that information. If you're working with another attorney on another type of case to recover funds like that, you always want to talk to that attorney, let them know you're filing for a Chapter 7 bankruptcy. During the initial consultation, the attorney is also going to ask you about income. Are you working? Is your spouse working? How long have you been working with your current employer? How much do you make each month? This is really important. Income is one of the driving factors to determine whether you qualify for a Chapter 7. To qualify for a Chapter 7, there is the means test analysis. The means test analysis essentially is the test that is done based off of your income to show whether or not you qualify for a Chapter 7 bankruptcy based off of your household size. So depending on what your monthly income is, there's a 6-month analysis that's done. The attorney will likely ask you for pay stubs for the last 6 months for everybody in your household that makes money. That way they can determine whether or not you qualify for that Chapter 7. This is an IRS standard. These numbers are changed and updated every year. For example, right now, the means test for a single person household is a little over $75,000 a year. So you can still qualify for a Chapter 7 if you make below that amount. That's roughly about $6,200 a month. So if you're making less than that amount, you automatically qualify, but it all really does depend on your household size, which is really important that if you are married, but your spouse is not going to file, their income also has to be taken into account during that calculation. Next, the attorney is going to ask you about your debt. What type of debt do you have? Do you have credit card debt? Do you have personal loans? Is it medical bills? Do you have tax debt to the IRS here in the state of California, to the Franchise Tax Board? Or do you have any domestic support obligations? Any past due domestic support obligations like child support or alimony? Do you have any student loans? Some of this debt might not be dischargeable, might not be erasable in a Chapter 7. Unsecured debt like credit cards, personal loans, medical bills, past due utilities, past due cell phone contracts, payday loan companies, those type of things are dischargeable. But some things that are not dischargeable are domestic support obligations, for example. So during your initial consultation, the attorney is going to find out, what's your marital status? Has anybody filed for bankruptcy before? What type of assets do you have? Is it a house? Is it just cars? Do you have a lot of checking accounts, stocks, cryptocurrency? Are you suing someone? They're going to ask about your income. What's your income been looking like for the last 6 months? Have you been unemployed? Is your spouse unemployed? Have you been doing Uber or DoorDash on top of your full-time job? All these things need to be taken into account. And then your debt, giving a ballpark. There is no dollar amount to qualify for bankruptcy. There's no specific dollar amount you have to qualify. There's no limit either, but you want to always have a decent ballpark figure for the attorney so they understand exactly what they're dealing with and where it breaks down. Taxes, for example, there's certain qualifications for some IRS or Franchise Tax Board taxes to get discharged. Unsecured debt, it's really just going to be a matter of you not using the cards prior to filing, so that it doesn't raise any issues of dischargeability. And then things like domestic support and student loans are not dischargeable. There's some caveats there, but you want to always talk to your attorney about that.